Hello everyone, my name is Shibani Ghosh. I'm a lawyer. I specialize in environmental law and I practice in courts in cases dealing with environmental issue. I'm also involved in research and writing, and I'm associated with the Center for Policy Research, a leading think tank based in New Delhi, where my work involves environmental law and regulation in India. And I've also worked with the Central Information Commission, which is an apex body under the Right to Information Act 2005, and some of my research and writing is on the right to information. The module that we are going to discuss today is the judicial remedies that are available in environmental cases. Now, as you know, environmental governance and environmental decision making has several direct and indirect implications on the rights and interests of stakeholders. For example, a decision to build a dam or a decision to mine a particular quarry could lead to certain types of air and water quality repercussions. There could be a decision to clear forests or to mine or to build industries or to dispose of wastes in a certain way. Or there could be certain form of inaction by the government, which decides not to do anything when it sees forms of environmental degradation. All these different implications lead to different kinds of consequences. And these consequences require some form of grievance redressal. While some grievance redressal can happen at the appropriate executive level, a lot of it really happens from the judiciary. So in today's class or in today's discussion, we are going to look at what are the remedies that the judiciary offers in environmental cases, or cases where there have been violations of environmental law, or cases where there has been environmental degradation and the lives and interests of people have been affected. Now, the outcome of this module, or by the end of this module, I hope that some of you will be able to understand what are the different courts, or what are the mechanisms that are available, starting from the National Green Tribunal, which is a specialized court for environmental cases, moving on to the lower criminal courts also, where certain kind of environmental crimes can be prosecuted, and then finally the higher judiciary, which constitutes the high courts and the Supreme Courts. Now, we will begin with the National Green Tribunal, which, as I said, is a specialized court or a specialized tribunal which hears and decides only environmental cases. The National Green Tribunal has been set up under the National Green Tribunal Act of 2010. The Act provides effective and expeditious disposal of cases as its objective. Disposal of cases, of course, relating to the protection of environment, including the enforcement of any legal right relating to the environment. Now, the National Green Tribunal is not like any other judicial body. It is actually a multidisciplinary body where there are judicial as well as non-judicial, or what we call expert members. These are people who have expertise or technical knowledge in various fields. They could be professors from universities, they could be retired bureaucrats, they could be people who have specialized knowledge in fields such as hydrology or sciences or social sciences. So these people are expert members in the body. Now, the National Green Tribunal actually replaced a body which existed before that, which was called the National Environment Appellate Authority, which had a similar but much limited mandate. The National Environment Appellate Authority could only be approached if you wanted to challenge an environmental clearance that has been granted to an industry. However, in the case of the National Green Tribunal, it has a much broader mandate, which we will discuss in just a bit. Now, what are the cases that can be brought before the National Green Tribunal, or in other words, what is the jurisdiction of this tribunal? Now, the jurisdiction of the National Green Tribunal can actually be divided into two, which is called the original jurisdiction and the appellate jurisdiction. What is the difference between original and appellate jurisdiction? Now, original jurisdiction refers to the powers of the tribunal to decide an issue for the first time before any other authority has actually made a decision on it. In comparison, in appellate jurisdiction, what the tribunal does is it sits in hierarchy, in a higher position than an authority which has already taken a decision. So someone approaching the tribunal in an appellate jurisdiction is actually challenging a decision or an order by another authority before the tribunal. Now, cases which fall under the jurisdiction of the National Green Tribunal cannot be heard in other courts, which means that if the National Green Tribunal can hear cases, for example, challenges against environmental clearances or forest clearances granted to projects, the cases can only be brought to the National Green Tribunal, and most likely judges in the Supreme Court or the High Courts will not accept such cases and will request petitioners to approach the National Green Tribunal. Now let us look at these two types of cases, under the original jurisdiction and the appellate jurisdiction, more closely. In the original jurisdiction, which is under Section 14 of the National Green Tribunal Act, all civil cases where a substantial question relating to the environment arises out of the implementation of 7 environmental laws can be brought before the National Green Tribunal. I must emphasize these are only civil cases, so criminal cases cannot be brought before the National Green Tribunal. Now, what are the 7 laws that we are looking at? These are really the 7 most important laws, with the exception of one, which I'll come to in just a bit. The laws are with regard to Water Prevention and Control of Pollution Act and the Cess Act in regard to that. The Forest Conservation Act, under which forest clearances are often granted to project proponents to be able to use forest land for non-forest activity. Air Prevention and Control of Pollution Act, often known as the AIR Act. The Environment Protection Act, under which several other notifications and bylaws and rules have been issued, whether it's regard to the environment clearance process or regulation of plastics, electronic waste, hazardous waste, municipal waste, coastal regulation zone. All these come under the ambit of the Environment Protection Act and therefore under the ambit of the National Green Tribunal. The Public Liability Insurance Act 1991 and the Biological Diversity Act of 2002. The notable exception, which is not under the jurisdiction of the National Green Tribunal, is the Wildlife Protection Act of 1972. One of the reasons given for that, and though there's no unanimity on it, is that the Wildlife Protection Act concerns mostly criminal cases, and since the Green Tribunal does not hear criminal cases, it wasn't brought within the ambit of the National Green Tribunal. As you can see, the notable exception to this list of acts is actually the Wildlife Protection Act of 1972. While there's no unanimity, but people say that one of the reasons why the Wildlife Protection Act has been kept out of the jurisdiction of the National Green Tribunal is because it mainly concerns criminal offences and not civil offences or civil cases, which are only the type of cases that the National Green Tribunal can consider. Now let's look at some of the examples of cases that can be brought before the National Green Tribunal in its original jurisdiction. So if there is an industrial complex which is leading to massive air and water pollution, there's groundwater contamination, then petitioners, who could be people who are affected by it or NGOs, could approach the National Green Tribunal challenging the environmental impacts of this industry as a whole. The difference is that they are not challenging a particular consent or a particular clearance granted to the industrial complex, but the whole environmental impact of the complex. Another example could be, as some of you perhaps know, the floods of Uttarakhand in 2013 and the massive impact that the floods had in livelihoods of thousands of people. A case has been brought before the National Green Tribunal in its original jurisdiction, challenging the contribution of irregular and unauthorized construction along the river valley, which led to massive destruction. And a third example is the rampant sand mining, rampant illegal sand mining that has been taking place across the country, which has been challenged before the National Green Tribunal to protect the beds, the river beds, which are getting affected by this form of illegal mining. Now, the decision of the jurisdiction of the National Green Tribunal also includes a direct violation of a specific statutory environmental obligation by a person, which affects the community at large, or substantial damage to the environment or property, or damage to public health, which is broadly measurable. If any of these criteria are met, whether the environment is affected or then the people are affected at large, or there's a specific environmental obligation which has not been met, then the National Green Tribunal's original jurisdiction can be triggered. The environmental consequences of a particular activity or measure could relate to a specific activity or a point source of pollution. So, for example, a particular factory would be a point source of pollutant such as sulfur dioxide or nitrogen dioxide. Now, the applications that are filed before the National Green Tribunal under its original jurisdiction have to be filed within a particular time limit, which in law is called a limitation period. The limitation period for these kind of applications is within 6 months from the date on which the cause of action for such dispute first arose. So, which means the first time on which the petitioner or the person bringing the case to court notices pollution, he or she or the group has 6 months to bring that case to court. If there is an additional period of 60 days grace that can be given beyond the 6 months, so 2 more months. However, the delay of bringing the case to the court has to be explained to the tribunal, and if they are satisfied that there was sufficient cause for delay, they may allow the case to proceed. However, if the case is brought beyond 6 months and 60 days, that is 8 months, then this case cannot be filed before the National Green Tribunal. Another set of cases which can be brought before the case under its original jurisdiction relate to relief, compensation or restitution of property, which is under Section 15 of the National Green Tribunal Act. So, for victims of pollution and other environmental damage, they can approach the Green Tribunal seeking compensation or for restoration of their damaged property or for restitution of damage to the environment. Now, application for relief and compensation and restitution of property has to be brought before the tribunal within 5 years from the date on which the cause of such compensation arose. Now, the reason, and again, like in the case of the earlier case that I discussed, there's a grace period for 60 days granted. But I must stop here to explain why this time limit is 5 years. It's 5 years because there have been cases where industrial accidents have occurred, but the impact of the industrial accident, such as the health impact, has only been noticed or has only arisen much later. And an example of that could be the Bhopal gas tragedy, where victims of the gas tragedy came to know of health impacts much later. So, such victims of pollution and industrial disasters actually have a much longer time to bring a case to court for compensation. They can come to court within 5 years from the date on which they actually come to know that they have been adversely affected by a particular activity or an industrial accident. Now, the kind of orders that the NGT can grant in such cases, it can direct restoration of the damaged environment. So, for example, it can tell a company to install sewage treatment plant to clean up a water body, to clean up the river, or it can direct compensation to be paid to victims of pollution, or it can direct restitution of damaged property. Now, we move to the second type of jurisdiction of the National Green Tribunal, which is the appellate jurisdiction under Section 16 of the National Green Tribunal Act. The appellate jurisdiction, as I mentioned earlier, involves challenging an order previously given by the government, and it can be done with regard to any of the 7 laws that I mentioned before. And I'd like to give certain examples of the kinds of orders that may be appealed against before the National Green Tribunal. For example, the environmental clearance that is granted under the EI notification of 2006, the forest clearance that may be granted under the Forest Conservation Act of 1980, or the consents to establish and operate that are granted by the State Pollution Control Board under the Water Act and the Air Act. These are 4 types of approvals or consents that are granted by these regulatory authorities under these 4 laws. If these are granted and people are not happy or are affected by these clearances, people can challenge the decision to grant the clearance. On the other hand, if the clearance has been denied or the consent has been denied, the industry which approached the government for such a clearance can approach the National Green Tribunal to challenge the decision of the concerned government agency. With regard to the appellate jurisdiction of the National Green Tribunal, The National Green Tribunal can be approached within 30 days from the date on which the order or decision that is being challenged has been communicated to the people. Beyond the 30 days, there's additional 60 days that is permissible, but only if the petitioner is able to convince the tribunal that there was a sufficient cause or reason for the delay in approaching the tribunal. The next question that comes to mind is who can actually approach the National Green Tribunal, or what is called in the legal parlance the locus standi, who has the standing. Before the tribunal, in fact, it is an extremely broad rule. Anyone literally can approach the National Green Tribunal. It can be an individual, it can be a company, a firm, a non-governmental organization, need not be registered. It could be a government agency, so for example, a municipal corporation or the State Pollution Control Board. Any person or entity can approach the National Green Tribunal as long as it is not frivolous and malicious litigation. Also, I must point out that the National Green Tribunal has adopted a liberal approach in understanding that persons do not have to be directly affected by a project or an order to approach the National Green Tribunal. Even if any citizen of this country living in Delhi is interested or wants to challenge a project which has been granted in the state of Arunachal Pradesh, the citizen can do so, because the Green Tribunal has held repeatedly that it is the fundamental duty of every citizen of this India under the Constitution to protect the environment. And therefore, if a citizen is based somewhere else and is not in close proximity of the particular project, he or she may still be concerned with regard to the environment and have the right to approach the National Green Tribunal. Now, what are the kinds of directions or remedies that can be sought with regard to from the National Green Tribunal with regard to its appellate jurisdiction? The National Green Tribunal, if it finds that a consent or a clearance has been given illegally or the process has not been followed properly, can cancel a clearance or a consent, or it can even issue a stay order or a stop work order, which means that no further action can be taken at that particular project site or industrial plant until further reconsideration. They can also they can of course reject an appeal before it and say that it doesn't have any merit, or they can ask governmental agencies to reconsider or reassess the situation. Unlike other courts in India, the National Green Tribunal actually has a time-bound requirement within a time limit within which it is supposed to decide. According to the National Green Tribunal Act, it must be the endeavor to dispose of the tribunal to dispose of applications within 6 months. However, it does sometimes take longer than 6 months because every party has to be given a proper opportunity to make representations. There could be certain inspections that have to be undertaken which are time consuming. So occasionally it does take longer than 6 months to decide cases. However, it's important to remember the Green Tribunal is still under a statutory requirement to try and decide cases within 6 months, because very often environmental cases are time sensitive, and if they are not decided, irreversible damage could be done to the environment and to the lives and livelihoods of people. The National Green Tribunal has all the powers of a civil court. Therefore, it means it has the power to summon witnesses, to require documents to be presented, to examine witnesses and such other things. It also has the power to give suo motu directions, which means that even if no party has approached it, it can give certain directions. However, I must point out that this power of the National Green Tribunal has been challenged before the High Courts and has not been decided as yet. The National Green Tribunal is not bound by procedure. So if you may have heard of the Criminal Procedure Code, the Code of Criminal Procedure, the Code of Civil Procedure, the Indian Evidence Act. These three form the core procedural law that governs Indian courts. The National Green Tribunal is not bound by them. The National Green Tribunal has been deliberately given the power to be innovative, to be able to come to effective conclusions in environmental cases. However, it has to be guided by the principles of natural justice. Its decisions have to be guided by the three important principles of environmental jurisprudence that the Indian Supreme Court has often referred to, which is the principle of sustainable development, the polluter pays principle, and precautionary principle. In cases of accidents and claims for compensation, the National Green Tribunal is required to adopt the no-fault principle of liability. Now, the penalty for not complying with the order of the tribunal is the following. So, if any person is directed by the tribunal to undertake certain measures and he or she does not do so, it could lead to 3 years of imprisonment and or up to a fine of 10 crore rupees. Now, in case of a company, this fine could actually go up to 25 crore rupees, and in case a violation continues even after a penalty order has been issued, additional per day fine for this continuing offence is also provided for in the National Green Tribunal Act. Finally, an appeal against the decision of the National Green Tribunal lies directly to the Supreme Court of India, which has to be made within 90 days from the date of the tribunal's order. However, if the appeal is not made within 90 days but made after that, the Supreme Court would have to be convinced for the reasons for delay. I just want to emphasize here that an appeal against the National Green Tribunal cannot be filed in the High Court. However, writ petitions can be filed before the High Court and Supreme Court under different constitutional provisions which are not restricted in any way by the National Green Tribunal Act or the functioning of the National Green Tribunal. Now, moving on to the next set of judicial remedies. Remember, we were talking about civil cases before the National Green Tribunal. However, there are several statutory violations or violations of environmental law provisions which constitute criminal offences. Now, complaints with regard to these offences have to be filed in a criminal court by appropriate government agencies. Now, let us look at some of the examples of criminal offences. Let us look at the Water Prevention and Control of Pollution Act of 1974 and the Air Prevention and Control of Pollution Act of 1981, which are popularly known as the Water Act and the Air Act. Under these acts, there are certain offences that, if committed, complaints have to be filed in the criminal court. Now, what could be an example of a criminal offence under the Water Act? It could be that a consent to establish has not been granted, yet an industry has started functioning. Another example could be that a consent has been granted and certain standards have been placed on the quality and the amount of discharge that can be allowed from an industrial plant into the stream. What is the effluence that's permitted? However, the industry violates these standards or goes beyond these standards, this would also be an environmental offence. If such kind of offences or illegal activities take place, then the concerned State Pollution Control Board, the Pollution Control Board of the state in which these offences take place, has to file a complaint either in the court of the Metropolitan Magistrate or the Judicial Magistrate First Class, but not in a court inferior to these magistrates. A private citizen, someone who is not part of the State Pollution Control Board, can also file a complaint against such an environmental offence. However, such a person would have to give a 60-day notice to the State Pollution Control Board of its intention, of his or her intention to file such a complaint in the Metropolitan Magistrates Court and the reasons or the alleged offences based on which this criminal complaint is going to be filed. And he has to give this notice for 60 days, after which he or she can approach the court. Another example could be of the Wildlife Protection Act. There are several offences under the Wildlife Protection Act which are actually criminal in nature. Examples of that would be hunting of protected species, illegal trade, smuggling or poaching of animal parts, body parts or meat or skin or hair, which is commonly traded, however illegally. All these are criminal offences, and complaints may be filed by designated government agencies such as the Chief Wildlife Warden, the Director of the Zoo, or the Director of the Tiger Reserve. These designated government agencies can file the case in the relevant criminal court. A private citizen, again, can also file a criminal case under the Wildlife Protection Act. However, he or she has to give 60 days notice to the central government of his or her intention to file such a criminal case and the alleged offence against which such a criminal case is being filed. Now we come to the third set of judicial remedies that are available to people in the form of the higher judiciary in the country. The higher judiciary is the Supreme Court of India and the high courts in all the states of the country. Now the higher judiciary plays an extremely important role and has historically played a very important role in environmental cases. As you must have read in other modules, the Article 21 of the Constitution, which guarantees the right to life, has been interpreted on several occasions to include the right to clean and healthy environment. Now the Supreme Court and the High Court have used this as the basis to engage in environmental cases before them. Under Article 32 of the Constitution, every person in this country has a fundamental right to approach the Supreme Court for violation of his or her fundamental right, and this includes the fundamental right to clean and healthy environment. What does this mean? It means that if my fundamental right to clean and healthy environment has been violated, I actually have a fundamental right under the Article 32 to approach the Supreme Court, and no law in this country, no law passed by the Parliament or the state legislature can take away my right to approach the Supreme Court. However, as you can imagine, the Supreme Court cannot be inundated with all sorts of environmental cases. So the Supreme Court is only likely to hear cases which involve issues across state boundaries, where several states are engaged or illegalities have been committed in several states, or the issue is of immense national importance, or of course if it has come in appeal from a decision of a high court. If there's any other court, such as the National Green Tribunal or the High Court of the concerned state, if the Supreme Court thinks that these courts provide an alternative and efficacious, which means a good effective remedy, then the Supreme Court will require the petitioner to approach either the National Green Tribunal or the High Court instead of directly coming to the Supreme Court itself. Now the High Courts can be approached under the Article 226 of the Constitution of India. Under Article 226, it need not just be a violation of a fundamental right of a person or an organization, but it could also be a violation of any other statutory right or the lack of enforcement of a particular statutory obligation. The higher judiciary, the Supreme Court and the High Courts, have a wide powers in what kind of directions they can give in environmental cases. So they can certainly direct payment of compensation, requirement for restitution of the environment, restoration of damaged property. They can also direct the conduct of assessment studies, direction to undertake inspections, directions to state governments or other government agencies to comply with statutory directions or requirements, and they can also enforce the rights of people approaching them, which means that if they believe that the fundamental right or any other right of people approaching them has actually been violated or restricted in any way, they can give whatever appropriate directions in the form of orders, judgments and writs to ensure that these rights are protected. Now occasionally these writ petitions that are filed under Article 226 of before the High Court and Article 32, as I mentioned before the Supreme Court, take the form of what are called public interest litigations, or PILs. Now PILs are a little different in nature because very often they are filed by people who are not directly affected, but on behalf of people who are affected but are unable to approach the court due to either social reasons, or they are too poor, or they are not able to reach due to certain cultural encumbrances. So for these reasons, some groups of people are not able to approach the court, and so their voice is voiced before the court in the form of public interest litigation. These public interest litigations are also typically with regard to massive environmental degradation which affects thousands of people. Several actors, several industries are involved, and it requires a thorough and long-term engagement of the courts in deciding or coming to any possible conclusion. And very often it is seen that the Supreme Court and the High Courts, even after they have given their final judgment, they continue to monitor the compliance of their orders to ensure that people are effectively able to enjoy their fundamental right to clean and healthy environment. Now let us look at some of the examples of cases where the Supreme Court has played a very important role in protecting the environment. It could be in the 1980s, there was rampant and illegal quarrying of limestone in the Dehradun Valley, which was finally brought to an end through a series of orders coming from the Supreme Court. Another example could be the pollution caused by tanneries in Kanpur and in Kolkata and in industries in Vellore in Tamil Nadu. All these cases of industrial pollution which had huge environmental impacts affecting the lives of thousands of people and damaging property and livelihoods of worth crores of rupees have been addressed by Supreme Court and the High Courts through various orders and judgments to bring some reprieve, to give some remedy to people. Currently, some of the cases that are before the Supreme Court is that of illegal mining. For example, Belari mining, where a lot of iron ore mining was taking place illegally, leading to irreversible environmental degradation in the area. Mining in Goa, sand mining across the country. Also, there's a case with regard to the death of elephants on railway tracks in the northeastern states. So there are several cases with regard to forests, wildlife, environmental protection, which are currently being heard by the Supreme Court, which is constantly giving orders and monitoring the implementation of its orders. Now, I'd like to conclude today's discussion by emphasizing the important role played by the judiciary in democracy. It's really the third pillar in a democracy along with the executive and the judiciary, and in India they play the critical role of checks and balances and ensure that the executive and the legislature do their job properly, that they do not in any way hamper the rights of the people, and that people of this country are able to enjoy and live in an environment which is pollution free, hygienic, clean, and they are not affected, their health and lives are not affected by environmental degradation. People's rights and interests have to be given this form of legal protection in any democracy, particularly if they are backward communities such as tribal communities, people living in vulnerable areas such as islands and coastal communities. These communities and their interests have to be given particular importance before the judiciary. I'll end today's discussion by quickly summarizing what we have discussed so far in today's module on judicial remedies in environmental cases. We began by looking at the National Green Tribunal, which is a specialized court looking at environmental cases, and discussed its jurisdiction or the kind of cases that it can hear, starting from original jurisdiction and the appellate jurisdiction. We talked about what kind of orders can the National Green Tribunal give. Then we moved on to the kind of cases or the environmental offences which can be prosecuted in the criminal courts of the country, and we discussed examples under the Water Act and the Air Act and the Wildlife Protection Act. And we finally moved on to the higher judiciary, which can be approached through the writ petitions which may be filed under Article 32 and Article 226 of the Constitution before the Supreme Court and the High Courts respectively, and the kind of orders that these courts can give to give some reprieve to people affected by environmental decision making, particularly in public interest litigations and cases bringing out rampant and massive scale of environmental degradation. Thank you, and I hope you enjoyed today's session and learned something out of it.